Hey everyone, welcome to the Explainer. Today, we're unpacking a massive, landmark ruling out of the Telangana High Court that honestly has huge implications for corporate leaders everywhere. If you hold a high-ranking title in a company, or even if you're just aspiring to, the legal nuances we're going to dive into today are absolutely essential. We're really going to draw the line and look at where exactly a company's responsibility ends and where an executive's personal criminal liability begins. Let's get right into it. It's kind of a terrifying thought, right? Imagine you're the captain of this massive ship, but deep down in the engine room, a deckhand makes a serious administrative error. Are you automatically a criminal just because you hold the highest rank on board? Well, that is the exact question at the heart of the case we're breaking down today. Just because you have director or CEO right there in your email signature, does that mean you're criminally on the hook for every single thing that happens below you? To figure this out, we're going to follow a quick 5-part agenda. 1, the executive's nightmare. 2, prosecution versus petitioner. 3, the high court's breakdown. 4, the insolvency factor. And 5, key takeaways for executives. Starting with part 1, the executive's nightmare, the Sankhya Infotech Limited EPF default. So picture this. The chairman and managing director of a company called Sankhya Infotech Limited suddenly finds himself facing criminal charges. The issue? An alleged default on the Employees' Provident Fund, or EPF contributions. Basically, the company deducted the EPF amounts from employees' salaries, but allegedly failed to remit them to the authorities. But here's the real kicker. The managing director was dragged into court as the sole accused in this entire mess. Now, the foundational concept at play here is vicarious liability. It's a legal principle where someone at the top is held accountable for the entity below them. But, as we'll see, it's definitely not a blank check to just arrest the boss. This principle is incredibly nuanced, and it's actually severely misunderstood by both enforcement agencies and business leaders alike. And you know, the timeline here is absolutely crucial. We're not talking about something that happened yesterday. The alleged failure to remit those deducted EPF funds spanned way back from March 2013 to December 2014. After that, the company actually underwent a completely successful corporate insolvency resolution process at the National Company Law Tribunal, the NCLT, in Hyderabad. This massive gap in time and the total change in corporate status leads us right up to 2024, when the managing director filed criminal petition No. 117096 to try and get these proceedings quashed. Moving on to part 2, prosecution versus petitioner, establishing the core conflict of culpability. This brings us right to the courtroom showdown in the case of N. Sridhar v. State of Telangana and Anner. So we have a literal line drawn in the sand here, with some really stark contrasts. On the left side, the state and the EPFO took a super strict stance. Money was deducted, it wasn't remitted on time, therefore a crime was committed and someone must pay. On the right side, the MD argued that his mere title shouldn't override the actual facts. He pointed out he had zero involvement in the day-to-day affairs, there was no material evidence of him misappropriating funds, and honestly, in a bizarre twist, the company itself wasn't even named as an accused. And just to emphasize the severity here, the MD wasn't looking at a simple slap on the wrist. He was charged under Section 406 of the Indian Penal Code. For those who might not know, Section 406 carries the extremely heavy, highly stigmatizing accusation of criminal breach of trust. It implies deceit, malice, deliberate theft. I mean, it's the kind of charge that can destroy a professional reputation literally overnight. Which brings us to part 3, the High Court's breakdown, Justice N. Tukaramji's 5 crucial observations. This is where the legal breakdown really happens. Instead of just taking the prosecution's claims at face value, Justice Tukaramji methodically dismantled their case. The court's first big point was an absolute necessity in corporate law. Prosecuting the company itself is a sine qua non. It is an indispensable condition. Because Sankhya Infotech Limited was never actually made an accused by the authorities, the judge realized the entire foundation of prosecuting the managing director was just fundamentally defective right out of the gate. And that brilliantly illustrates the second observation. The judge looked at the case and found literally zero material evidence tying the MD to the daily operations of the EPF remittances. The prosecution was essentially arguing, well, he's the boss, so he's guilty. The judge firmly rejected this, reinforcing the settled legal fact that a fancy job title on an org chart does not automatically equal criminal liability. The third observation hinges on a very famous legal concept, mens rea, criminal intent. The judge essentially looked at the prosecution and asked, How on earth can you charge this man with criminal breach of trust when there's absolutely no evidence of criminal intent? Breaking it down, the judge outlined all the ingredients required for a Section 406 charge and basically found they were all missing. There was no evidence the property was ever entrusted directly to the MD, no proof whatsoever that he dishonestly misappropriated it, and again, that complete absence of mens rea. The court made a massive distinction here. Simply missing a statutory payment deadline, while definitely bad, does not magically fulfill the severe requirements you need to prove a deliberate criminal breach of trust. For the fourth observation, the court pointed out some glaring procedural gaps. Under the EPF Act framework, authorities are supposed to properly determine liability first, then build a legally admissible prima facie case, and only then launch a criminal prosecution. But here, the record showed the authorities aggressively skipped those mandatory first steps and just jumped straight to step 3. Moving on to Part 4, the insolvency factor, how NCLT proceedings shifted the landscape. Remember that NCLT process we touched on earlier? Well, it turns out that successful insolvency resolution changed everything. In a major twist, the prosecution actually conceded during the hearing that the outstanding EPF dues had already been cleared. The judge noted that with those dues completely settled and the company resolved through the NCLT, the basis for continuing to criminally prosecute an individual executive for past delayed payments was, to put it lightly, significantly weakened. Finally, Part 5. Key takeaways for executives, the reality of corporate criminal liability. Ultimately, the High Court declared that continuing these proceedings against the MD would be an absolute abuse of the legal process, and they officially quashed the case. And they left us with this essential checklist. If you're a corporate executive, a business owner, or a legal pro, you need to commit this to memory. Your liability has to be grounded in actual evidence and your direct daily responsibilities. Authorities simply can't use your spot on the organizational chart as a shortcut to a criminal conviction. They have to prove intent, they have to include the company in the charges, and they absolutely have to follow due process. So, knowing what we know now about these strict limits of vicarious liability, I want to leave you with this one vital question to ponder. Who is actually making the day-to-day operational decisions in your business, and does your internal documentation accurately reflect that reality? Trust me, it's a question that could quite literally keep you out of court. Thanks so much for joining me on this explainer, and I'll catch you on the next one.